Greetings and salutations. I'm Christopher Platt, reporting for Your Black World News with an article from the Miami New Times. Don't forget to subscribe to this channel and visit theblackbusinessschool.com to learn about financial literacy and how you can grow your business today. The case is one of the biggest black eyes in the history of the Miami-Dade Police Department and State Attorney Catherine Fernandez Rundle's administration. In 2015, local cops, elected officials, and Rundle stood at a lecture and declared that then 15-year-old DeAndre Charles had murdered Joseph Raxon, a prominent New York City rabbi. Rundle then revealed an utterly ridiculous witness-drawn sketch that looked more like a discarded Muppets character than a real human being. But roughly a year later, prosecutors were forced to admit Charles didn't kill the rabbi. In an explosive lawsuit filed in federal court last Tuesday, Charles's lawyers say they now have proof that both Rundle's office and the detective involved, Michael Brajic, possessed evidence from the beginning that proved Charles's innocence. Yet they charged the teen anyway and plastered his face on TV next to the humiliating sketch that later went so viral it became part of a Kevin Hart comedy routine. In short, the suit alleges the county could have and should have avoided ruining the life of an innocent 15-year-old by labeling him a murderer. According to the suit, Brajic, the police detective, had ample evidence that a group of young men was involved in the killing. He was repeatedly told that Charles was home with his family when the homicide occurred. In fact, Charles's family now says that mere days after the killing, a confidential informant identified 4 men who were likely involved in the crime and tangentially knew Charles. Another civilian named 2 of the same men. Police interviewed one of those suspects in April of 2015. The man, listed as JS in the lawsuit, basically confessed. JS said he and 3 others who had been named by the tipsters were at the scene when Raskin was killed. Firearms evidence also linked one of those men to the slaying, the suit says. But Brajic and Rundle's office pushed the grand jury to indict Charles based on faulty DNA evidence and statements from the witness who drew the bad sketch. They held this event that looked like an old perp walk, Charles's lawyer, James DeMiles, tells New Times. They had this poster-sized picture of DeAndre. They said they had his DNA, this great case against him, but they didn't have it. There were members of Miami-Dade County on stage, members of Miami-Dade PD on stage. Then they whipped out that sketch that the witness drew that looked like a Sesame Street character. So my client gets ridiculed. He was the butt of jokes of Kevin Hart. He was internationally known. Notably, the suit also states law enforcement obtained no new evidence in the case from the day cops arrested Charles until he was released 333 days later. Neither prosecutors nor police responded to messages from New Times yesterday. Both agencies typically do not comment on active litigation. If proven, the case will be another scathing indictment of both MDPD and Rundle, who's been the county's top prosecutor since 1993. She was the subject of internal scorn after refusing to charge 4 prison guards involved in the death of Darren Rainey, a mentally ill man who was placed in a scalding hot prison shower by guards who wanted to punish him. Rainey died in there. One guard who escaped charges, Roland Clark, later became a Miami Gardens cop. Clark has since been repeatedly accused of official misconduct and having sex while on duty. A Miami-Dade County medical examiner, Emma Liu, dubiously claimed Rainey had no burns on his body when he died. Rundle later recommended that Liu receive an award for her work. Rundle's office also recently bungled DNA evidence in a different cold case murder. In 2014, prosecutors charged a man in a 1986 killing, but in August of 2018, they quietly dropped the case in what was likely a misuse of DNA forensics. Since prosecutors dropped Charles's case in 2017, no other suspects have been arrested in connection with the murder of the rabbi, who was fatally shot August 9, 2014, while he walked toward a temple in a heavily Jewish section of North Miami Beach. Some people initially questioned whether the murder was a hate crime, but it later began to seem more like a robbery gone awry. Raskin, who lived in New York City, was in town visiting relatives. After he was killed, hundreds of supporters gathered in Crown Heights, Brooklyn to mourn his death. The case remained open for 16 months. Then, in 2015, prosecutors became convinced that Charles, just 14 years old at the time of the murder, had tried to rob Raskin and then killed him after discovering he had no money. Rundle's office convened a grand jury, which ultimately indicted the boy. Rundle and many high-ranking county employees then showed up for that infamous 2015 news conference. This is a prime example of how prosecutors and police can work together, Rundle said at the conference. She later added that Raskin didn't have any money on him, so Charles shot and killed him. Raskin's daughter painted Charles as a vicious thug who should have been prosecuted to the fullest extent the law allows. At the news conference, Rundle unveiled a sketch drawn by a murder witness. Multiple news outlets suggested it was the single worst facial composition sketch they had ever seen. It was a mix of borderline racism and Bert from Sesame Street. During the press gathering, Rundle held the sketch next to a photo of Charles's face. The juxtaposition was somehow proof that she and her team had caught the killer. Perhaps more important, Charles's family had said from day one that the teen was nowhere near the North Miami Beach temple when Raskin was shot. Blair Charles, the suspect's mother, told the media that her son was home when the murder occurred. "All my kids were here on that Saturday," she told CBS Miami. Another relative, Willis Archibald, confirmed Charles's alibi. 100% certain he didn't do this. The whole family was home when this incident occurred. The new lawsuit appears to show that law enforcement officials bizarrely pushed to indict the wrong suspect despite being told someone else had committed the crime. According to the legal complaint, both a confidential police informant and a civilian tipster identified the four men, listed as KC, DP, MK, and JS in the lawsuit, as having been at the murder scene. The informants both said some members of the group had been driving around in a black Cadillac Escalade. The suit contends neither the informant nor the tipster mentioned Charles. On August 15, 2014, two of the four men, KC and DP, arrived at Charles's home and asked if the boy's older brother was around. The brother wasn't there, so the two men asked Charles if he wanted to take a ride in the Escalade. The suit says the teen was quote-unquote wowed by the luxury SUV and wanted to sit in it. But during the joyride, cops stopped the vehicle. They detained all three and questioned them. The suit says KC and DP gave obviously inconsistent testimony about where they were when Raskin was killed. Neither man said Charles was with them the day of the murder. At least two of the four men named by the informants have a history of armed robbery. One even openly admitted that his friend KC was a known burglar and robber, the suit says. Roughly a year later, law enforcement obtained even more evidence tying the four men to the slaying. Suspect JS had been arrested on unrelated charges. While in custody, he confirmed he and the three other men had been at the murder scene. The three men that JS identified and described as being involved in the murder of the rabbi were the same three men named by the confidential informant and two of the same three men named in the Crime Stoppers tips, the suit says. JS did not mention the plaintiff, speaking of Charles, as having any involvement in the attempted robbery and murder. JS also admitted that the four regularly committed burglaries together and that the morning of the rabbi's death, they had been unsuccessfully trying to rob houses. JS then described what KC and DP were wearing that day, the suit says. The description closely matched the statements from eyewitnesses. On October 1, 2015, a Miami-Dade County crime lab technician examined bullet casings taken from the murder scene. The tech said the casings closely matched those from an armed robbery that took place the day before Raskin's homicide. The suit says that Casey was already a suspect in that robbery and that police did not suspect Charles had anything to do with that case. There was no explanation as to how the plaintiff could have possibly obtained possession of the firearm following the armed robbery on August 8, 2014, for its use in the murder of Rabbi Joseph Raskin, one day later on August 9, 2014, the suit states. Charles's legal team also notes that although KC was a good bit older than Charles, the two looked somewhat alike, thus, quote, causing the possibility of a misidentification to be high, end quote. So Charles's lawyer, DeMiles, tells New Times that Detective Brajic relied on one witness statement made from more than 100 feet away and DNA evidence from the gun and Escalade to wrongfully name Charles as the killer. DeMiles adds that he believes Rundle's office then relied heavily on the single police detective's incorrect interpretation of the facts. In fact, DeMiles claims Bragic and MDPD misinterpreted DNA evidence too. There was a difference here between a DNA match and just a probability of inclusion, DeMiles explains. When you're talking about inclusion, you're talking about it being a probability of multiple people. What they thought might have been a gene linking the DNA to DeAndre might have just been a gene for curly hair, for example. After dropping Charles's case, the state attorney's office released a closeout memorandum admitting that due to a, quote, change in lab protocols, end quote, the office could no longer confirm that Charles's DNA matched the evidence taken from the scene. Moreover, the police say they relied on cell phone tracking technology to link Charles to the murder scene, but in fact, Charles didn't have his phone on him that day. Someone else did. This evidence was in the detective's possession and control the whole time, DeMiles says. I think the state attorney believed the detective, but the detective really dropped the ball. Charles ultimately sat in jail from December 2015 to November 2016, 333 days. He was released on house arrest until January of 2017. Now, DeMiles adds, he's doing good, but he'll still be out places in public and people will look at him. He says he'll think, I'm getting this mean look because people think I'm a murderer. Thanks for tuning in. Don't forget to share this video and let us know what you think. Also, don't forget to subscribe to the Your Black World YouTube channel and visit theblackbusinessschool.com today. I'm Christopher Platt reporting. Until next time, shalom.